I used to sue institutions that knew children were being abused and did nothing about it. And New York City was one of those institutions. After I left the DA's office, I went to a large civil litigation firm. And after I left there, I worked at a boutique plaintiff side firm. We sued institutions that knew children that were in their care were being sexually abused and they looked the other way. New York foster care, private boarding schools, religious organizations. The reason that we could even bring these cases was because the legislature set up a mechanism to allow the victims of these crimes to bring cases that happened years ago to the limelight and expose the people who preyed upon them. For most of these cases, the victims had long been barred from bringing their lawsuits because they are much older now, and all of these injuries happened when they were very young. The Child Victim Act in New York opened a window that allowed the victim of a childhood sexual assault to sue the institutions that enabled their abuser for a 2-year window that was extended for a year in COVID. The reason that that law is important and the reason allowing these victims to come to the forefront to tell their stories is because children who are sexually abused repress that memory. They're damaged by that memory, and they don't have the ability, mechanisms, or safety net to tell their story to people who can do something about it. Before the CVA was passed, by the time a child could understand exactly what happened to them, the law had told them it was too late. And these cases revealed the same pattern over and over again, that the institutions that were set up to protect these young, vulnerable children failed to protect them, put them in positions that enabled abusers to take advantage of them. And when they called out for help, they turned a blind eye. The hardest part of the work wasn't even learning of the abuse. It was finding out how many people saw it, heard it, and chose silence over helping out a child.